But the more important part, if you file that within 1 year of the time a previous claim was denied, whether it was at the regional office or even at the Board of Veterans' Appeals, that keeps the effective date that we were just talking about. And if you prevail on the supplemental claim, despite the previous denial, your benefits can potentially go all the way back to the effective date of that filing.
So very powerful tool.
Very powerful.
Yeah. How about the acronym BVA?
Okay, BVA just stands for Board of Veterans' Appeals. Board of Veterans' Appeals is the internal appeals body within the VA that reviews basically all lower level decisions that you wish to appeal. I mean, you don't have to appeal them all, but any you're unhappy with can be appealed to the Board of Veterans' Appeals. And the board is obligated to decide claims that were explicitly raised before it.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Tony Francis Jackson.
Welcome to Victory Over VA. This is our podcast that's your guide to unlocking veterans' disability benefits. If you're a veteran applying for benefits, be sure to subscribe for the latest developments in VA disability. I'm Francis Jackson, and this is Christian Terrison, and we're veterans' disability attorneys at Jackson and MacNichol. We've helped thousands of veterans to get millions of dollars in benefits that have been denied by the VA. We created this podcast as a resource for veterans who are applying for disability benefits. But it's really for a much larger audience. It's for anyone with an interest in veterans' disability issues, whether you're a family member of a veteran, a relative or friend of a veteran, or simply someone in the community who wants to support our veterans. Anyone who wants to understand a little more about the disability benefits available to our veterans can come to this podcast. So today, we're going to talk about all the jargon that the VA uses that just confuses the heck out of veterans. Let's take it away.
All right. Yes, the jargon indeed. So to start with, I guess we'll begin at the beginning. Now, try and keep this explanation short because we've got a whole episode on this topic. But what does the term service-connected mean in a VA disability claim?
Okay. Service connection just means that the VA has determined that a particular medical condition is related to the veteran's military service in such a way that he or she is eligible to be paid financial compensation for the impairments caused by that disability.
All right. That's about as succinct as you can get for service connection.
It is.
Next on our list is C&P exam.
Sure.
What is it? Why is it important?
Okay. You need a quick piece of background for this to make sense. The VA has two kinds of cash disability benefits. One is called service-connected compensation, which is mostly what we're talking about. But there's also a veteran's benefits called pension, non-service connected pension. And C&P exams are for compensation and pension examinations, which are medical examinations scheduled by the VA, usually through a contractor, for the purpose of helping the veteran's adjudication person to understand medically what's going on with the veteran, both in terms of whether the claim should be connected to the veteran's service and in terms of the nature and severity of the symptoms for rating purposes if service connection is granted.
Another perennial favorite as far as opaque terminology is the VA rating schedule. You know, what is it and what bearing does it have on a veteran's disability rating?
Sure. The VA rating schedule is also sometimes referred to as VA math. What the rating schedule does is to aggregate all of a veteran's service-connected disabilities into a single rating. And the VA doesn't do that in an ordinary arithmetic way. So, for example, if you have a rating for 50% and a rating for 30% and two ratings for 10%, they don't add up to 100%, even though in ordinary math we would think they would. What the rating schedule does is to implement what conceptually seems to make sense. The VA takes a particular rating, say for example, you have a rating of 30% for some condition. And then you get another rating. When you get the next rating, say it's a rating of 20%, for example, they don't take 20% of 100. They take 20% of the 70% that's left after the first 30% rating. So it's really 14% instead of 20%. And so each time you add a rating, the VA takes that percentage that's assigned, whether it's 10, 20, 30, 40, 50, whatever it is, from the percentage that's left from the previous ratings. So if you had previous ratings that take you to 60% and you got a 10% rating, that's 6%. And then you're now at, because of the way they do the rounding, you're at 70%, but if you get another 10%, that's only 30, it's only 10% of 30, so it's only 3. So it doesn't change your rating percentage at all. And that's very hard to explain to people, but I'm happy to say that if you go on our website at veteransbenefits.com, there is a built-in disability calculator that you can use to plug in all of the disabilities that are service-connected at their ratings, and it will tell you what the combined percentage is.
And I guess while we're on that topic, can you talk a little bit about a scheduler rating versus an extra scheduler rating?
Sure. Scheduler ratings are really what I was just referring to. You take a particular condition, you look at the rating schedule, and you assign a rating to that condition. So, for example, with diabetes, a common rating might be 20%. But the VA does recognize that there are times when the symptoms that a particular veteran has don't match the way the rating schedule is built. Obviously, the VA is trying to look at the entire world of medical disabilities, and it's simply not possible to reduce that all to a schedule and be able to say, well, these symptoms for this condition automatically mean this. There are always going to be symptoms that aren't factored in, or combinations of symptoms more commonly that aren't factored in. So when you're talking about a scheduler rating, you're simply talking about applying what's in the rating schedule. You look at the condition, you look at the symptoms, and you say, okay, this person has diabetes and they're insulin dependent, so we give them this rating. But what happens is there are some conditions where the rating schedule essentially says, well, your condition is not more serious than X, whether it's 10% with tinnitus or 20% in my diabetes example or 70% in a mental health condition, whatever it is. But the actual impact of the symptoms is sufficiently beyond what's contemplated in the schedule that the VA acknowledges that they have to consider the possibility that you should get what they call an extra scheduler rating, which simply means you're stepping off the schedule to look at an unusual constellation of symptoms. Usually we're talking about unusual in the sense of overall severity compared to what the schedule contemplates. There's a recent case from the court involving Parkinson's disease where, because Parkinson's can have so many different variants, the court looked at the issue of whether, if you look at just the rating schedule, the rating would be X, but because of the fact that there are these other symptoms that are not contemplated by the schedule, then we really have to consider rating Y as opposed to X. But it's that kind of stuff. And it can be either for a particular condition, you can get an extra scheduler rating, or it can be for a total disability based on individual unemployability rating, TDIU. The VA has the authority to award a 100% payment level rating under TDIU if your symptoms are severe enough, even if you don't qualify under 38 CFR 4.16a, which says you have to have either a combined rating of 70% and within that one condition that's rated at least 40%, or a single condition rated at 60% or higher. And even if you don't fall within that, the VA has the authority to consider an extra scheduler rating because of the particular combination of symptoms and resulting impairments and limitations makes you unable to work. And that's called an extra scheduler TDIU rating.
And that actually dovetails nicely with the next term, TDIU. So you really covered a lot of it, but if you want to spell it out.
Sure. TDIU is just an acronym for total disability based on individual unemployability. It's also sometimes referred to as just unemployability or IU. Sometimes they leave off the TD. But all it means is that your condition combines sufficient different impairments that when considered in combination, even though you don't reach 100% on the schedule, you are in fact disabled from work and should be paid as though you are at 100% on the schedule. So TDIU is a shortcut to get to 100% payment based on the severity of your symptoms and the resulting limitations.
This next one is always one that I like to see come up in a case, a presumptive condition.
Presumptive conditions are actually fairly straightforward. What it means is that based on medical evidence accumulated over the years, Congress has authorized the VA to presume that a particular condition is in fact related to your medical service. So normally, for service connection, you have to show something that occurred in service, injury, illness, whatever. You have to show current disability, and you have to show a medical connection between those two, connecting the condition to service. What the presumption does is to take out that last piece and automatically connects the condition to service. A fairly common example is if you served in Vietnam and were exposed to Agent Orange, the VA will presume that if you have diabetes, it's as a result of your service, and will make that medical connection for you without you having to make a showing that there is a medical connection.
Okay. And this is a term that can have a major impact on the back benefits award in a case, the effective date.
Okay, effective date can be a little confusing, but essentially the way the VA works, in almost all circumstances, the earliest date you can get paid for disability benefits is the date that you filed your claim with the VA. There are some weird exceptions that we're not going to cover here, but that's typically the date. So what happens is usually it takes a while for claims to be granted. Even claims that are granted relatively quickly by the VA, there's just a certain amount of processing time. So the most rapidly most claims are decided is in months. It's not uncommon for it to be in years. So the effective date is important because that's the date that the benefits start from. And when you get your service connection award, the VA goes back and looks at the effective date and pays you back to that date based on whatever the benefit amount that's been established for your claims is. Month by month, they calculate it out, go back and pay it. So effective date's a big deal in terms of past due benefits. And the way it works, the VA can go back to the earliest date of your claim, or they may decide, for example, if you've put in for an increased rating, say you had a 10% rating for your knee, you put in for an increased rating, and you put that in January of 2022, and now it's been granted. The VA may decide that, in fact, the symptoms really didn't get sufficiently worse to justify a 20% rating until January of 2023, and they may pick that as the effective date for the increased rating. But typically the earliest they can go back to is the date you filed the claim, which in our hypothetical would be January of 2022.
That's why it's always important to file
Always
fast.
important.
Yeah.
Yep.
And how about NOD? 3 very important letters if you get an unfavorable decision or a lowball decision.
Sure. NOD is just the VA's term for an appeal form. It's technically stands for Notice of Disagreement, and it means that you've told the VA that you disagree with whatever the rating was, whether, as Christian said, it was an outright denial or a lowball rating. Say they gave you a non-compensable 0% rating or a 10% rating, that can be appealed, and the way you appeal it is using this Notice of Disagreement form. It's also called Form 10182 currently.
All right. And another VA form that's a frequent flyer, VA Form 21-526EZ. What is it, and when would a veteran use it?
That's a form that's typically used to start a claim. We talked a minute ago about effective dates. Usually the effective date will be the date you filed your 526EZ form with the VA. If you mail it in, it'll be the date they received it. If you send it electronically, it'll be the date they received it. If you carry it in, it'll be the date they received it. So it's always good to get it to them as soon as possible when you're making a claim.
And this next term doesn't come up as frequently, but can also have a huge impact in a case. What is a DBQ, and how is that used in evaluating a veteran's disabilities?
Well, we talked earlier about C&P exams, and a C&P exam, as we mentioned, is a medical evaluation for purposes of the VA's analysis of the claim. A DBQ is a very specific form that the VA uses with their examiners to try to capture a picture or snapshot, if you will, of the severity of a claim at that particular point in time. And it's a disability benefits questionnaire, DBQ, but that's what its purpose is. It's to give the VA rating folks a picture of the severity of your claim, and it goes to both whether you should get service connection at all, and if so, it also goes to the level of rating in most cases.
Now, how about a supplemental claim? What's that, and how is it different from other types of appeals?
A supplemental claim is something that didn't exist until February of 2019 when the AMA came into effect, but it's a very interesting concept. What the supplemental claim does is one of two things, depending on the timing. It can be used to reopen any claim that's been previously denied and is now beyond the appeal period. So say you filed a claim in 2019, it was denied in 2020, you didn't appeal it, it's now closed, there's no way to reopen that claim, but you can go back and raise the same underlying claim, say a problem with your left knee, for example, in a new supplemental claim. And that lets you kind of reopen things and have the VA look at it again. But the more important part, if you file that within 1 year of the time a previous claim was denied, whether it was at the regional office or even at the Board of Veterans' Appeals, that keeps the effective date that we were just talking about And if you prevail on the supplemental claim, despite the previous denial, your benefits can potentially go all the way back to the effective date of that filing.
So very powerful tool.
Very powerful.
Yeah. How about the acronym BVA?
Okay, BVA just stands for Board of Veterans Appeals. The Board of Veterans Appeals is the internal appeals body within the VA that reviews basically all lower level decisions that you wish to appeal. I mean, you don't have to appeal them all, but any you're unhappy with can be appealed to the Board of Veterans Appeals. And the board is obligated to decide claims that were explicitly raised before it or any claims that were reasonably raised by the record that was in front of them.
Okay. Now, this is another term with an entire episode dedicated to it, but we'll see how we can do on a succinct definition. Secondary service connection. What is it and when does it apply?
Sure. Secondary service connection is really what the name implies. The claim that you're seeking benefits for is secondary to another claim that has already been filed and found to be service connected. So, for example, if you have diabetes, unfortunately one of the common side effects of diabetes is nerve damage in the, particularly in the feet, can also happen in the hands. And if you have the underlying condition, here we're talking about diabetes, and then you manifest these secondary effects, they can be service connected.
Mm-hmm. So here's one that can get overlooked sometimes, but in cases where it applies is very critical. Aid and attendance.
Sure. Aid and attendance is a special benefit that the VA provides for veterans who are disabled to the point that they can no longer do typical activities of daily living, whether it's bathing or dressing or feeding themselves or being able to go out of the house to buy groceries. You know, there are various disabilities or combinations of disabilities that can be service connected that unfortunately are so impairing that they keep the veteran from doing typical activities of daily living and require that the veteran have assistance from someone else to complete those tasks. And when that happens and you can prove that to the VA, then they will grant an additional monetary benefit based on the need for aid and attendance.
In a similar vein, another one that can get overlooked is SMC. What is that and who's eligible for it?
Well, SMC actually covers a whole range of benefits. It's very expansive. At the high end, SMC is for people who have lost multiple limbs, for example. At the lower end, there can be things like loss of use of the creative organ, and that is a benefit that's available for both men and women. So that's kind of the lowest level on the scale, and then these various special conditions are laid out in the regulations, and they range from, you know, the loss of use I was just talking about, which is rated kind of at the bottom of the schedule, all the way up to a very, very significant payment if you have a traumatic brain injury that basically limits your ability to function very severely. That's kind of at the top of the scale. And as I mentioned, loss of multiple limbs, you know, there are lots of different things on the schedule, but this special monthly compensation, or SMC, is available for all of those conditions. There are particular subsections, whether you're talking about L or M or N or O, there's a whole raft of them. But they're essentially the VA's way of trying to go beyond the compensation that's based on the schedule and compensate people for particularly severe losses.
The last one we'll have time for today is also quite a doozy, AMA. What is that acronym for, and how did it change every veteran's claim going forward?
Well, the AMA is a package of legislation that became effective in February of 2019. and it's the Appeals Modernization Act. The interesting part is that the AMA designation leaves out the fact that the actual title of the legislation was the Appeals Modernization and Improvement Act. And sometimes the VA seems to skip over some of the improvement parts. But regardless, that's a little bit of cynicism on my part, I fear. But the point is that this is a major change in the legislation, and it controls how VA claims are handled. It does not affect claims that were pending in what is now called the legacy system, which is basically all claims that were pending before February of 2019. But most of those claims have now kind of been worked through the system. There are still some remaining, and in fact, we still have some we're working on. But the AMA changed the system by adding a lot of complexity. What it did was to create multiple options for how to seek review of an initial decision by the regional office. It allows for what's called higher level review. It allows for the supplemental claim we talked about earlier. And it allows for the notice of disagreement appealing to the Board of Veterans' Appeals. Moreover, at the Board of Veterans' Appeals level, it created 3 different tracks or lanes for review, where you could have direct review, which is simply limited to having the board look at what's already in the record and what the regional office did and say, yep, that was okay, or no, they got it wrong and they got to go back and fix it. Or you can go in the evidence submission lane where you file your notice of appeal and notice of disagreement appealing, and you submit with that or within a short window of time after that additional evidence that you want the board to consider, and you say should be a different result than what the regional office came to because of this additional evidence that I'm providing you with. And the board reviews that on the papers. There's no hearing or anything, but they review the documents and make a decision. And finally, the third option is the hearing lane, which is pretty similar to the traditional VA hearing at the Board of Veterans' Appeals that has been available for many years. But the changes under the AMA are twofold. First, evidence that goes into the veteran's file after the initial rating decision, but before the hearing at the board, is not considered by the board. It's just like it doesn't exist. Second, any evidence that the veteran wants to have considered by the board that wasn't in the file and considered at the time of the regional office decision on the claims has to be submitted either at the hearing or within a 90-day window thereafter. Typically, testimonial evidence, talking to the judge and telling him about the claim, will happen at the hearing, and written evidence, medical reports, vocational reports, affidavits from people who know the veteran or know about the facts will be submitted in writing after the hearing within 90 days. But that also includes things like intervening decisions by the VA that may be helpful to the claim. Those don't get considered unless you take a copy of that and refile it in that 90-day window after the hearing, which is frankly just silly, but that's how the legislation works.
And I will point our viewers to our episode on the Appeals Modernization Act and all the ins and outs and impacts for additional detail too. But thank you for joining us today. This has been another episode of Victory Over the VA. Please be sure to like and subscribe, and tune in again to join us next week.
We'll look forward to seeing you then.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.